Mr. Brown.
Please, the court. First, I'd like to thank the court for rescheduling this for oral argument. Very much appreciate that. Case is a sad case. Gene Bartley's been one of the most respected senior lawyers probably in Iowa's history. Done an awful lot of good things. I don't have to recite them all. Most of them are in the brief in terms of lawyers helping lawyers, in terms of her participation bringing women into practice, her participation in bar politics in a positive way, is a role model for a lot of people, myself included. What brings us here today is how, unfortunately, two rather large, complex estates might have got the best of her. They took too long. Representations made weren't fully accurate. Basically, as far as neglect and how long it took, she's not really arguing that. Obviously, she knows it took too long. Did any of these people that were part of the estates, meaning the heirs, complain? No. Were any of them deprived of ultimately disposition and getting what they needed? No. But did it take too long? Yes. What Gene's issue, what brings us here today, and there's not much question about it, is because of this delay, and I think clearly embarrassment from the delay, she made misrepresentations as to the status of the matter and made those misrepresentations within her office and certainly to members of the bench.
Is the evidence or the information contained in the letter that was attached to the stipulated facts fair to consider in determining the resolution of a question about her misrepresentations?
Well, I think certainly the letter, Tom Hobart's letter, was attached to the stipulation. Again, we didn't have a trial. Nobody presented any evidence. Rarely do Mr. Grace and I really agree on something, as we did here, but we actually reached a stipulation, much has happened in a couple of other matters, I think in the Barnhill case, and agreed things had occurred, and this was the proposed sanction. But in terms of how the commission, the Grievance Commission, interpreted Tom Hobart's letter, I take serious issue with, because essentially he's made a hypothesis that this was somehow a forged letter or a check. There isn't any proof of that, and certainly we adamantly deny it. The fact is, as far as were the estates, did they go too long? Did it take too much time? And were there situations made where she was talking to two different judges in Johnson County? That's not disputed. But in terms of forged documents and the manner in which I think Tom was hypothecating, but he didn't have any evidence of it. Well, and I don't think that's a basis for it.
Certainly have to acknowledge that those are extremely odd facts. We don't see that very often in a state where a lawyer takes out her personal checkbook and writes a check to pay a claim in an estate.
Well, I have to admit my lack of knowledge of probate is going to become glaringly obvious now. In terms of what practice is,
and
I
then
don't
she
know.
ended up, that wasn't enough. She then gets a cashier's check and pays the claim.
Sure.
So why would it be so odd for the board to take those facts and use it in concluding that she misrepresented the court and her partners when she said that those claims had been properly paid?
Two questions. I can't object, I guess. A little compound. Number one, can you take the letter into account, and could the commission take it into account? Yes, Chief, they certainly could. But in terms of the interpretation that she forged a document, a check, or a letter, I'm not suggesting it's a model of clarity. I'm not even beginning to go there and wouldn't suggest it. But I do think, again, this is reading between the lines, and I'm representing a client who's stipulated to some serious situations and submitted to this situation with the coordination of grievance counsel to put it behind us without the taking of evidence. But certainly the suggestion that she would be suspended for 6 months or perhaps have everything ended in her career when she's essentially ended up this way, we certainly didn't anticipate that. And if we really thought for a moment that the letter was going to be used and interpreted that way by the grievance committee, I think we'd really seriously reconsider the stipulation. I certainly never would have considered that was going to happen.
Isn't that a hazard you take when you stipulate?
It is indeed, Judge.
Our cases are clear that we have the right from the stipulation to find the facts as we may and any inferences from there. So you decided to stipulate instead of try it, you can't take that back.
Oh, I'm not suggesting that I could. And I think personally at this level, when the 7 of you are sitting in a de novo review, you could determine there's going to be a public reprimand or there's going to be something more than 60 days. I understand that. But I think under these set of circumstances, I don't think there's a basis to go where they did. But you're right, Justice Wiggins. Once you go with a stipulation, obviously you're not contesting the underlying elements. But I certainly don't think it's a reasonable interpretation of the Hobart letter to use it as it was done. And I didn't mean to interrupt you, Justice Mansfield.
No. I was interrupting something else. So, Mr. Brown, I mean, there's 2 letters that interest me. One is the Hobart letter that we've talked about. The other is this Hills Bank and Trust letter with is at least purports to be from Brad Languth. Sure. And I will say from my personal perspective, that letter pause, and if that letter is a forgery, that is something that might put this case beyond the stipulated recommendation. And what's your position on that letter? Is it a genuine letter that was truly signed by Mr. Languth, and it is not a forgery? Is that
I don't have any evidence. Excuse me, I didn't. I don't have any evidence that it is anything other than an authentic letter. I don't have any evidence that it was a forgery. I don't think the grievance committee did either. Certainly, and I would agree with you, Justice Mansfield, if basically there's a criminal charge or basically it's proven beyond a reasonable doubt that there's a forged document, obviously you're looking at a different situation. I don't think the evidence was there. I don't think that's a reasonable interpretation of Tom Hobart's letter. I don't think that's a reasonable interpretation of what was stipulated to in the underlying matter. But I also understand that as far as sanction goes, all 7 of you conclude, I think on an ad hoc basis to some extent on every case, what's the appropriate sanction under the circumstances.
Letter is genuine. The letter says Ms. Bartley's checking account was debited for the amount of the check on the same date, meaning August 5th. Mm-hmm. There ought to be evidence of that. But as I looked at the bank records, they don't show a debiting on that date. Am I right?
Well, in terms of the bank records, I wouldn't suggest for any reason that they're a model of clarity. But the reality is, if I could explain how we did this, I can't think of an ethics case I've ever defended anyone on where we had this situation. Jean Bartley's down in Iowa City. I go down to Iowa City. She comes up here. I have the entire files of everything she has. I actually physically hand them over to Mr. Grace as grievance counsel. Did we go back and go back and go back? And the answer is actually, Justice Mansfield, we really didn't. I certainly think the intent was there are no secrets, there is no hidden evidence, it's all here. Additionally, and so there was no question about it, before the Hobart letter was written, there was full disclosure of everything to him as well and to his law firm. But in terms of, did we take evidence on that, in terms of the foundation of this, or to explain where was this document or where was not this document, that really was never done. We reached a stipulation, and frankly, I think this sorry chapter had come to an end until I read the decision, and that really, while it's a risk of a stipulation for sure, I thought the penalty, the sanction was unduly harsh. I think on de novo review, I think this court can take a look at that, but we're certainly not suggesting there weren't serious problems in the administration of these 2 very complex estates.
Should this court give any special consideration when the board and the attorney agree on the sanction?
Well, it seems to me, I again, never had the opportunity to be sitting where you're all sitting, but I will have to say this. I think if the encouragement is to bring these matters to conclusion in an honorable and relatively efficient and quick way, number one. And number two, where you actually have the lawyer, licensee, basically writing a letter acknowledging this situation. I mean, this actually came to the attention of Charlie Harrington's office and Mr. Grace, not because of the Hobart letter. It became public information in terms of, I should say, private information in the enforcement line, because Gene Bartley wrote a letter. The estate people didn't write a letter. The judges didn't write a letter. Tom Hobart didn't write a letter. Gene Bartley wrote a letter. And things kind of unravel from that. But we actually submitted something. We had interaction, obviously, with Mr. Grace's office after that, but that's where it started. So in terms of should you have deference to that, I certainly think de novo, you can decide how you want to handle it. But I do think generally, I think the answer is yes, because I think you would want to encourage that. I think the attempt has been made, I think, over time to have a pretty open, transparent, fairly quick process, and one where if we can reach an agreement, that we move forward that way, and not with the trouble of scheduling hearings, having transcripts and all of that, that we proceed forward. But certainly the last word is obviously in this courtroom. I understand that. And when we had the opportunity to actually have oral argument, we wanted to take it.
Okay, I'll ask a related question as far as what weight or deference we give recommendations. Should we give less deference or weight to the recommendation of a commission when there wasn't a full-blown evidentiary hearing? They weren't evaluating demeanor and credibility. It's just a paper record that we have.
Good question. I mean, my view is, again, I'm attempting to look at the full-blown of a lot of ethics opinions that you've written and I've had an opportunity to read, and some arguments I've had the opportunity to make, and that is, I think sometimes you defer and sometimes you don't. As far as in this particular instance, it seems to me the stipulation by the parties as it was made, without the taking of evidence at all, I think, it seems to me, if I was a member of the court, I'd give it a great deal of weight. Whatever did or didn't happen when the panel of the commission met or considered it or reviewed the stipulation, we don't have a record of that. I don't know what really persuaded them.
Our cases are clear, though, that we are the ultimate arbitrators of the penalty.
Absolutely.
And there's some issues of whether or not the party should even be stipulating to a sanction. I mean, we're the ones who have to decide what is correct based on the fact situation and based upon what other lawyers have gotten for the same thing. And in order to avoid the good old boy system where people could stipulating and not get involved in things, I think we've taken the position that we're the ultimate arbitrator, and our cases have been pretty clear on that. Are you asking us to change our law on that?
I'm not. Of course you're the ultimate arbitrator. But I do think when stipulations are made between the parties and it's presented, I think you give it very serious consideration. Because I think if it doesn't matter, and basically you can stipulate to certain violations of the canons or whatever, but as far as sanctions, that's ours to decide. I don't see that really encouraging people to try to resolve these absent a contested case.
We don't allow stipulations of violations of canons either. The only stipulations we allow are the facts, and our cases are clear that based on those facts, we have to decide whether or not there is a violation, and based on those, and we've found cases where they stipulated violations and we said it wasn't there. And based upon our review of the findings of fact, based upon the stipulation, we decide the sanction. What you're saying is you want to turn that all upside down and let the lawyer and the disciplinary board control what happens and what violations are what.
Actually, I think you're misinterpreting what I'm attempting to urge. And to the degree you might think that I'm suggesting that, I'm certainly not. I do think when people do stipulate to things in terms of either violations, facts, underlying evidence, without credibility findings being made at all, it seems to me, I think if I was sitting where you're sitting, I would certainly give a certain amount of credit to whatever the parties came up with. But in terms of who's the ultimate arbitrator, not much question about that. I've never tried to urge that. And I certainly think under the circumstances,
one of the problems
I
with
think
that,
there's...
Mr. Brown, is that when someone stipulates to a violation that's really not, and we write a decision and say these facts are that violation, then everybody thinks that's a violation in the future. And that can't be. And when people stipulate to a sanction and we find something wrong, and every other person got X amount of time, but they only stipulated to Y amount of time, that creates inconsistency. So that's why I'm having problem with your basic premise of agreeing to what people stipulate.
Mr. Chief Justice, might I have just a moment to respond to that? My basic premise is not that you're not to find a word, but my basic premise is this. I think when you have a case presented in this fashion, I think you take it under very serious advisement, and particularly, I realize you don't have to defer to credibility findings either, but you generally do. I also understand you're trying to be consistent in what you're doing with lawyers, and you can line up all your cases on a lot of these issues, and perhaps we can have that discussion some other time and place. But to suggest that they're all consistent and that you can make a prediction for sure under a given set of facts, this is exactly what's going to happen, that's not been my reading of your authority. Thank you very much.
Thank you as well, Mr. Brown. Mr. Grace.
May it please the court, Mr. Brown. By way of housekeeping, a small matter, the appendix contains 2 copies of Exhibits 1, 2, and 3. So pages 132 through 238 are duplicates of pages 26 through 131. The fighting issue here is whether the commission should have gone beyond the stipulation and recommendation and proposed a 6-month suspension rather than a 2-month suspension. It's probably true that the commission recommended the 6-month rather than the 2-month suspension because they found that the respondent had fraudulently prepared documents. Now, this is part of the background of paragraph 8 of the stipulation on appendix page 515, that the respondent misrepresented the status of the creditor claims to the court and to her law firm. That paragraph 8 refers to Exhibit 5, the partial court file, which includes the affidavit at issue, a supposed letter from the banker, and the check, which 3 things are claimed to be fraudulent. And those are at appendix pages 446 to 449. Now, let's take the affidavit first.
Preliminary question, Mr. Grace.
Yes, sir.
I mean, you agreed earlier that 60 days was the appropriate sanction. Is that still your position, or is it your position that the commission sanction is correct?
No, I'm arguing for the commission sanction now. I think it's my job when they recommend something that I think is reasonable to back them up.
Okay,
And
thanks.
Okay. So if we look at regarding the affidavit first that we're concerned about, is that a fraudulent document? Page 6 of the reply brief well, the affidavit is at page 446 and 530 of the appendix. And on page 6 of his reply brief, Mr. Brown states that the affidavit accurately states that the check in question was submitted or was transacted. To the contrary, the affidavit does not state that the check was transacted or cashed or negotiated. Now, the respondent's brief also says that the board asserts that Mrs. Bartley's October 2, 2014 was used to support her dishonesty. There's a word left out there, and that word is affidavit. So it should have read Finally, the board asserts that Mrs. Bartley's October 2, 2014 affidavit was used to support her dishonesty. And the date is also wrong. It's October 2nd, 2013 rather than 14.
Ask a question, Mr. Grace?
Yes.
Because this has to do with that letter that I asked Mr. Brown about, the letter, the Hills Bank and Trust letter. Is it the
Right.
board's position that that's a forgery?
Yes.
And am I correct that that the letter states that this check in the amount of $1287.55 was presented for payment at this bank on August 5th, 2013, and Ms. Bartley's checking account was debited for that amount on that date, but then you go to the checking records, which are in the record, and there's no such debit that occurred on that date, right?
Exactly.
And would you agree with me that maybe that letter, if it's a forgery, might support the more discipline in the more serious area that the commission recommended?
Absolutely. Yes, that's one of our contentions here, is that Mrs. Bartley concocted this fraudulent banker's letter.
Did the board take the position or believe that that letter was fraudulent when the attorney disciplinary board entered into the stipulation for a 60-day suspension?
We didn't put that in there, where there would have been no stipulation if we had tried to expressly get that in there. I realize that. But in putting in the Hobart letter, both the commission and this court is certainly allowed to find that by reason of the exhibits which are in the record. That's our position. Now, Mr. Brown says that there are mere typing errors, and but in that we complained about in that banker's letter, and some of the mistakes could be thought to be mere typing errors, but we submit that whether a check cleared or not is not a mere typing error, and Exhibit 31 shows that the check did not clear. The respondent says that any person faced with similar, with potential punishment would surely prepare a fraudulent document with the utmost care. Well, that's like assuming that criminals don't make stupid mistakes. But we all know that criminals, even the bright criminals, do make stupid mistakes all the time, and that's often why they're caught. Now, paragraph 8 of the stipulation also refers to Exhibit 31, the bank statement, which shows that the check didn't clear. That's why we've got that exhibit in there. And paragraph 8 of the stipulation refers to the Hobart letter, which describes the check, the affidavit, and the letter. Now, the respondent says that the Hobart letter does not contain any concrete evidence as to why the check is a forgery. We don't agree with that. The Hobart letter on appendix page 526 refers to this check a couple different times. First, at one point, the Hobart letter mentions a photocopy of the front of the check. But the Hobart letter also goes on to say, we now question the authenticity of the Languth statement, that is the letter, insofar as the original check shows no endorsement or other indication of having been transacted. Hobart had seen the original check, it was floating around in the copy machine. So he mentions photocopy of the check, which is in the record, and he also mentions having seen the original check, which, you know, the back of it shows no endorsement. So then Mr. Hobart also says, we are credibly informed that the check attached to the affidavit was never transacted. We therefore question the authenticity of the language statement, which indicates that the check was transacted. So he did have two things to point to that the check was a forgery. Looking at the check itself, and he knew that it had never, had been credibly informed that it had never been transacted. And he only had credible information. We have the actual bank statement.
Mr. Grace, before your time runs out, let me shift gears to the sanction that should be imposed here, because ultimately we are talking about some form of sanction on this lawyer. You've identified several cases in your brief, and there are more that would place the forgery type actions by the lawyer, if we were to find that, that would place that in about a 6-month suspension range. Are there circumstances in this particular case that would support mitigating, lessening that sanction, or increasing that sanction?
Well, we think that 6 months is about right. The Gottschalk, Walker, and the Humphrey cases that we cite involve serious neglect of several estates plus misrepresentation to the court. And we certainly have that in spades here in these
how
two
much weight
cases.
how much weight should we give the facts that of the exemplary service of this lawyer for 40 plus years and everything that she has done, and Mr. Brown has touched on quite a bit of that. How should we weigh that? And how old is she now?
I don't know. I believe upper 70s,
See, there's not
80s.
how,
Okay.
how should we weigh all of that in formulating the sanction?
Well, she certainly did have considerable service to the bar over the years. It should be weighed. You know, if conceivably it could be a revocation case if a younger person had engaged in all these dishonest activities. So, you know, I think perhaps it's already been taken into account by the Grievance Commission. I don't want to minimize her service to the bar. You know, everybody's a combination of good and evil, and unfortunately, Mrs. Bartley just seems to have, in her later years, just been subject to not telling the truth anymore. And the main thing you have to be concerned about is she qualified to practice law? You know, it doesn't appear like she is. But, you know, on the other hand, I think she's pretty well retired now, so we don't, you know, the board is not suggesting revocation, but certainly the length of suspension is something that ought to be taken into account with these mitigating circumstances. We like to defend the Grievance Commission when we can. 6 months sounds about right to us, and it seems to be in line with some of these other cases where the lawyers are neglecting their cases, their probate cases, giving the court phony reasons, you know, every 6 months, some phony reason why the estate's not closed. Now, regarding the self-reporting aspect, Mr. Brown mentioned, I It can be a mitigating factor in some cases, but here we have this self-report letter from her, Exhibit 1, dated January 23, 2013, only after first a judge brought these estates up to one of her partners, who then discussed it with her. And so at Appendix 524, Mr. Hobart got a call from the judge, Judge Russell, about the 2 old estates. He then met with her and discussed these matters with her, and then subsequently she self-reported. It's our position she shouldn't get too much credit for self-reporting under these circumstances. The judge and the firm partner being involved, Mr. Hobart, we're speculating, but he may have told her that if she didn't report it, he would be obliged to under Rule 8.3. So, and then when she did report, she only reported the minimum that she had been caught on, not the other violations. Thank you. We urge the court to impose the sanction recommended by the commission.
Thank you as well, Mr. Grace. Mr. Brown, you may present your rebuttal.
Hey, police court. I wonder if we'd had the stipulation and the grievance commission had determined a public reprimand was enough, if we'd be back. I'm not really certain. Apparently what Mr. Grace is saying, whatever the commission does, not whatever the stipulation was when he represented the board, he's going to go with whatever the commission decides. That's what I heard.
I don't put too much weight in that because we've got another case today where the board is disagreeing with the commission in their recommendation. So, but why don't you tell us why something less than the 6 months is warranted if we have a forged letter here?
I'll do my best. That's why I asked for argument. You start with this proposition. You have somebody who's really had a career of honorable service to the profession for 50-plus years. That is a major plus. Most of the things that have happened within this profession, within this state, involving lawyers helping lawyers, this person put in place. That's a big thing. The fact that when we get to this issue, she's had a career of complete support for the profession, all positives, is something that weighs in her favor. The fact that she's basically given service pro bono to people all over the state for 50 years is a plus. The fact that basically she did self-report, although David attempts to minimize what she reported, is a plus. I mean, again, my read of the opinions, and obviously all of you, when you collectively get together as 7, ultimately will decide the sanction, of course. But those are all factors that go to mitigation, and I think have impacted what's happened in a good number of cases with a lot more egregious situations than have been alleged here, where a lot less of a sanction has been imposed than here. So all I'm suggesting, Justice Mansfield, is this. I think ultimately when you get that kind of in the calculus of how you determine what's right under these circumstances, I've been here where I've left, read an opinion, and thinking, gosh, this ultimate sanction, it doesn't fit with what I thought were the other opinions, but that was the opinion of this court that day. In this particular instance, I think there's a lot to look through that and suggest that a lesser sanction is appropriate. I think the Barnhill case, as I recall it, I think you reduced it from what was recommended, I think, by the commission, and I think it can be done. I think it should be done. I think there are cases where it's appropriate. And in terms of weighing it, in terms of what Mr. Grace was saying, well, if it was a younger lawyer who hadn't had these years of service, revocation might be appropriate. Now, I consider that hyperbole of the extreme. I don't think there's anything in this record
Well, I think that may
to
be
support
right. But
revocation.
frankly, for me, the forgery issue is key,
Sure.
I think.
No, The alleged forgery.
If we were to find that there's insufficient evidence on that issue, a lesser sanction than the 6 months might be certainly arguable. But if we find, as we can, based on the evidence submitted, that there was a forged document, then you end up in a more serious sanction area, it seems to me. Notwithstanding the mitigating factors, I think there's no question that you've got some mitigating factors here. But a forged document strikes me as a real significant violation, and I'm sure it strikes you as that. And we do have checking documents that at least suggest that there may be a problem here. So give me pushback on what I've said, please.
Let me do the best that I can, Justice Apple. I agree that you ultimately have to determine if you believe, by clear and convincing evidence, there's a forgery. And I don't believe, even weighing it, looking at it, that they proved it by clear and convincing evidence there's a forgery. That you may have a suspicion, based on the evidence, that this doesn't line up quite right. But to suggest that based on what Tom Hobart says in a letter, nobody put under oath, the banker from Hills was never put under oath. As far as the original document, we don't have it here. The fact that all of those things exist do raise a question on whether or not, by clear and convincing evidence, it's been proven these are forged documents. And I don't believe, under the evidence, I don't believe it was proven by that burden of proof. That's our position. Thank you.
Thank you as well, Mr. Brown. The case is submitted. We'll now hear the arguments in the last case, State versus Tyler.